Next case we're going to hear is United States versus Boccone. And Ms. Burnham, whenever you're ready, we'll hear from you.
May it please the court. Mr. Brown spent 2.5 years working as a nurse practitioner at a pain management clinic in Virginia. During that time, he, of course, wrote numerous prescriptions for pain medication. He was charged with and convicted of unlawful distribution based on 3 out of all of those prescriptions. But because the government simply ignored an essential element of that offense, his conviction cannot stand. Charles Brown was registered to prescribe controlled substances. Therefore, it was not a crime every time he signed a prescription. Under the Controlled Substances Act and the applicable regulation, dispensing the medications he prescribed is not illegal when a medical professional does so through a prescription issued for a legitimate medical purpose within the usual course of that individual practitioner's professional practice. Accordingly, this court has required that to convict a medical professional for writing a prescription, the government must prove beyond a reasonable doubt that that practitioner did not have a good faith belief that the prescription was for legitimate medical purposes in the usual course of his professional practice, or that it was within the bounds of medical practice. Therefore, to convict Mr. Brown, there needed to be evidence that he was acting outside the usual course of his practice as a nurse practitioner when he issued those 3 prescriptions. But as the government agrees, it offered evidence only for the standard of a physician, not for a nurse practitioner, even though no physician was even charged in this case. And then the government held Mr. Brown to that standard of a physician. Virginia law, however...
What was that standard?
The standard for a physician was the standard that the government's expert testified to. She stated that a physician needs to review prescriptions, needs to monitor the prescriptions that are being given, particularly those that are like the ones Mr. Brown was convicted of prescribing, opioid prescriptions. But Mr. Brown...
That's not a standard to review them? What's the standard to review them for what?
Well, there's a number of components. One would be you need to review them to make sure that they're being taken appropriately. There's urine screens that are done.
Would Mr. Brown have to do all that?
Mr. Brown...
If he's going to be prescribing, if he prescribes and is authorized to prescribe, shouldn't he be sure that the medicine is being used appropriately, screening is done, urine test is done, and so forth?
Yes, Your Honor, under the supervision of a physician.
I know, but set aside the physician. I mean, we have a lot of instances where the physician either was very callous or was involved in a most peripheral manner. Doesn't the nurse practitioner have a duty, a medical duty to the patient?
Yes, Your Honor, and this is why...
What's the duty?
The duty is to comply with what he has a good faith understanding is within the scope of medical practice. Therefore, Mr. Brown, when he was prescribing, he was doing so under the supervision of someone who was telling him...
Tell me again, I want to follow up on Judge Niemeier's question. What is the standard that you say was wrong here? As I understood it, it was this element that it must be prescribed for a legitimate medical purpose. You say that's wrong?
No, the legitimate medical purpose standard has to be, filled with some sort of fact-specific analysis. There's no definition of what...
But doesn't Mr. Brown have to exercise some judgment as a nurse practitioner?
And
when he's, especially when he's prescribing. When he's authorized to prescribe, and in prescribing, aren't there standards that he should abide by himself and not just say, I followed orders?
Correct, but the question is, where does that standard come from? Where is he getting that standard?
You said that the court gave the wrong standard. I asked you what the standard was, and you said, well, to see that the drug was used appropriately and that there's a urine test. And I'm saying, isn't that what Mr. Brown should have done?
Well, the standard for a nurse practitioner isn't in the record because there was no
Well,
evidence
what do you
on that
proffer
standard.
is the standard for a nurse practitioner in prescribing the drugs?
The standard, I mean, I would continue to say, is with reference to what he was being told was the correct standard. He can get that through education from.
I'm not telling him where he learned it. I'm asking him what is the standard that a nurse practitioner has to abide by in prescribing drugs?
That was what the government needed to
I'm
offer
asking
evidence
you,
on.
as a matter of law, what is the standard?
Standard for a nurse practitioner is, practicing good medicine under the supervision of someone. It depends on the state.
There has to be a
Here-
difference between a nurse and a nurse practitioner. It seems like to me you are presenting the case that Mr. Brown was just a nurse, but not a nurse practitioner, who just followed instructions. Doctor says, go give him a shot. He doesn't. He doesn't think about what the purpose of it at all. But this nurse practitioner is given a special status, can actually go and give medicine without that doctor even being anywhere around. He's been given a general authority to do it. And here's someone who's not, and by the way, which charges are you relating to? Are you talking about distribution or conspiracy?
Both, Your Honor. But, okay, to answer the first part of your question, that is not
Isn't there a little
actually.
difference between the conspiracy basis and the distribution? I mean,
Well,
one,
if
the intent
Mr.
aspect of it, and in terms of how the agreement affects it on one end, and the conspiracy, and then with distribution?
Well, if Mr. Brown didn't know that what he was doing was wrong, then it's hard to say how he intentionally agreed.
In both instances, it seems to be your position is he just did what he was supposed to do, and that is whenever he was told to give someone some medicine, he gave it to him. That's the end of it.
I think
Doesn't matter if it came from Mr. Boccone or wherever, but this authority had to come from some higher person other than him. So once he got that, he did what he was told.
I think it's a little more nuanced than that, Your Honor.
Nuance it a little bit more for me beyond that. Then what more was he required? What duty beyond that do you assert he was required to have?
Okay. In Virginia, there's a written practice agreement that a nurse practitioner, not a nurse, the nurse practitioner must have with the supervising physician. And there is testimony from his supervising physician that they were in daily contact, that
So you're not addressing a standard. The question that was asked you is, what is the standard? You started your argument out with saying the government used the wrong standard. And you also said something I want to follow up on briefly, that this man didn't know that he was he didn't know of all these things, even though he's administering thousands of pills to a person that I think almost common sense would tell you that it's inappropriate.
he knew that he had the safety net of the supervising physician.
So he didn't
and
think he had
was
any
not-
independent duty as a medical practitioner. He
No.
thought he could hide under orders. It's sort of like the head of the government telling you to assassinate somebody. You say, I was just following orders.
There, if you had evidence that the person knew that assassination was wrong, which you probably
Well,
have,
that's my
then that
point
would be
here,
fine.
is
There's-
doesn't the nurse practitioner have a duty, and a duty imposed by law, in administering prescriptions and prescribing drugs to do something? Follow safe medical practices, be sure that the patient needs it, don't overprescribe, ignore attempts to defraud him. Somebody comes and lies and he believes the person's lying, wouldn't he say, I can't administer this?
Sure, of course. I
Okay,
think
now
all of,
what is the standard, and why is it different from any medical practitioner within the scope of the medicine being administered?
this is why the good faith part of this is so important, because what I'm trying to say is that because he was a nurse practitioner and had this agreement, he believed that as long as his supervising physician was saying this is within the bounds of medical practice, this was the basis for his education. When he came,
You're basically saying I was following orders.
when you're following orders and there's no evidence that your following orders was outside the scope of
Well,
practice.
that's the issue. If it's outside the scope of normal medical practice, and the government attempted to prove in this case, and the jury found that they did prove that these prescriptions were out of bounds.
There was no evidence, though, on those 3 charged prescriptions that those were outside the bounds of medical practice, of anyone's medical practice, Dr. or Mr. Brown's. There was really no evidence at all on those 3 charged prescriptions.
Was he involved in the prescriptions to honesty?
There was evidence that he was. His name is on the prescription. But there was also evidence that Mr. Boccone went in and forged Mr. Brown's name on prescriptions. There was also evidence.
Were there any prescriptions that Mr. Brown signed to honesty?
Yes, the record includes all of his prescriptions with Mr.
Okay,
Brown's
let's not
signature.
stick to the ones where something else. I mean, the jury can rely on anything to convict. And if there's some where he signed the prescriptions and they were out of bounds, and so I suggest those prescriptions to honesty were pretty clearly out of bounds. Don't you agree?
I disagree, Your Honor, that in all circumstances, the prescriptions to him were outside of the bounds of medical practice. There was evidence.
We don't need, that's not the standard of all of them. We're talking about where there's some from which the jury could have convicted him.
No, we're talking about this one particular charged prescription. And there was evidence that Mr. Honesty had real pain problems, that all 3 of these patients who received those charged prescriptions had pain problems. There was no evidence on the specific charged prescription that that one was outside the bounds or
Which
not
is this,
for
April 5th? Or which prescription? The April 5th one? Or?
For each of those 3 charged prescriptions. Mr. Honesty did not testify about that prescription. And Mr. Dow did not testify about that specific prescription he received. And Mr. Rogers, who did not testify at the trial, obviously didn't mention it. The expert did talk about that prescription, the one to Rogers. She did not specifically mention, either in her expert report or at trial, the prescriptions to Dow or to Honesty. As for the prescription to Rogers, all she said in the report was there was a prescription.
Wasn't Honesty the one that getting thousands of pills and then returning some to the clinic, and they were found in the drawer? And
they were found in Mr. Boccone's
4 different
drawer.
types of medicines were being prescribed each time?
Yes, and if you look at Mr. Honesty's testimony, what he was saying is he had an agreement with Mr. Boccone, not with Mr. Brown.
It doesn't matter if Mr. Brown was dispensing them and it was beyond the medical pale.
Well, what the evidence actually showed was that Mr. Brown decreased Mr. Honesty's prescription. Then Mr. Boccone came in, forged Mr. Brown's name on the prescription, and increased the dosage.
What did Mr. Brown say?
Mr. Brown said that he never prescribed outside the bounds of medical practice for any of the individuals.
We were particularly with Mr. Honesty referencing June 7th, 2010, is that correct?
Yes, I believe that's correct.
And doesn't the I'm sorry.
I'm sorry, just let me correct that. I don't believe that Mr. Honesty ever testified specifically about the date of the charged prescription.
All right, but count 7 references June 7th, 2010.
There is no reference in Mr. Honesty's testimony to that date.
Does that matter?
I
Is
think
there any evidence in the record about that, the medicine administered on that date?
there are prescriptions issued
Okay.
on that date with the name Mr. Brown.
Okay.
But there was no testimony tying a specific prescription outside the bounds of practice to those prescriptions. And he did suffer from real pain conditions.
The expert witness did offer that testimony, though.
She did not testify about that specific prescription for OxyContin on June 7th, 2010. She just made general observations that the practice was outside the bounds of a physician's.
Mr. Honesty
Practice.
informing Mr. Brown that he'd suffered 3 overdoses and Mr. Brown continuing to prescribe the medicine.
Along with testimony that prescribing to known addicts is not necessarily outside the bounds of medical practice from Dr. Courier, I believe, who was the supervising physician at the time the prescription that was charged was written.
Okay, I think, do you have a little bit of rebuttal? Not much.
Okay, I also have a sentencing argument, if you have any questions on that.
Yeah, well, I think your time's up now, but
Thank
try to
you.
catch it on rebuttal. Okay, Mr. Awanoka.
Yes. Good morning, Your Honors. John Iwanoge appearing on behalf of Mr. Paul Boccone. Let me start out, Judge Niemeyer, by first answering the question that you posed with respect to the pill bottles that were found at the Chantilly Specialist Clinic with respect to Mr. Eric Honesty.
Well, I'm not, that's not a big deal. The idea was that Honesty was in an arrangement where apparently he was returning the pills, OxyContin pills, that he obtained through prescriptions. Isn't that right?
That's what he claimed. However,
there's evidence of it, but that isn't, you know, this record is pretty big. There's
Yes.
a lot of evidence in this case.
Yes.
And to make an argument that there's a lack of sufficient evidence from which the jury could have found a conspiracy and the various violations is a big task, because you have to take on the hardest evidence against you.
yes.
The jury can consider any of that evidence. It can disregard some, and we don't know what it considered. So the effort on your part and on Ms. Berman's part has to be to address all the evidence, the hardest evidence against you, if you're going to make a sufficiency of the evidence argument.
Yes, Judge. I'll refer the court to page 474 and 475 of the joint appendix that addresses the fact that Special Agent Aaron Wader, who actually seized the photograph that is exhibit 36H, that is the photograph that had the pill that you referred to with Eric Honesty on it, that specific bottle, the Special Agent on 475, questions from Mr. Williams, could not tell if the bottles contained any pills. There was subsequent testimony by Mr. Boccone that they are required to return their old prescriptions if they're being given new prescriptions. So when they are returned, there's a destruction log that we went through at the trial because I was trial counsel.
That doesn't answer my question on that I was directing. That wasn't, I did say, didn't they find the pills? But my question wasn't Mr. Honesty, wasn't there testimony that he was returning pills to the clinic?
He was required to return pills to the clinic before he's giving new pills. Example, Judge, as his testimony showed, if you're giving 70 pills, and then at some point Dr. March or Nurse Practitioner Brown decides to change the level of the medications that you're taking, you are required, as part of making sure that there's no diversion or that the patient is not given medication or selling it, you're required to bring it back. Then
Why are you required to bring it back?
so that there's no diversion.
Who required it?
The clinic, Chantilly Clinic, required that it be returned so that it is properly accounted for, so that there's no diversion, which is what the government claims in this case that was not being done. And then there's a destruction log that was entered or used in this case that shows that the medications are returned, then destroyed before the doctor or nurse practitioner issues new medication.
And you say there was evidence in this case to show that he returned them because he was supposed to for purposes of destruction because he was given another prescription?
Yes, King Dow testified as to how the process works. That's my memory from the transcript. From the trial. King Dow
That may be a take on it, but I think the government is going to say that the evidence showed that there was a prescription of a large amount, and in order to give him an increased amount, there was an agreement to give him some back so that the clinic could have some there. But he was given large numbers of pills, wasn't he?
It depends on how you define large number, Judge Niemeyer. Let me give you an example, at least in talking to the experts that we used in this case. When somebody gets a 4 milligram OxyContin, for example, for purpose of example, an individual then complains of continued pain. In order for you to increase the medication, you may be either given 2 4 milligram pills whereby you're taking 2. It may reflect that you're taking 2. So it looks like you're giving more medication. However, the milligram is actually what you control. I know that the joint appendix is enormous in this case, and if you go through the task, at least of looking at each individual patient and an individual increase that is talked about in this case, it is not the number of pills that controls, but the milligram. If you look on the joint appendix 592 579 to 583 and 592 to 593. Even the doctor's own expert, even the government's own expert, Dr. Hamil Root, considered specifically her words to the effect that there's really no number that is set as something that one can say that this is the right number of medication or this is not the right number of medication. Specifically appears on our brief on page 19.
Let me ask you, just to cut through this a little bit, are you arguing that there's no evidence to convict, insufficient evidence to convict Mr. Boccone?
I will submit that there's
Is
insufficient
that what you're trying to argue?
in addition to other arguments, but let me start out by arguing that Dr. Hamil Root's report and testimony should not have even been.
Can you just answer my question first?
Yes.
Are you making an argument that the government didn't have sufficient evidence to convict in this case?
Yes, Judge. Yes, Judge. Because Judge Niemeyer, if you look at the entire record, one thing that comes across is there are people that testified, but then not one of them said that Mr. Boccone signed the signature. Not one. The only person that claims medication was given to him.
Ms. Burnham just said Mr. Boccone forged Mr. Brown's signature.
That's the claim that she makes. She represents Mr. Brown. But then you can go through this record, Judge.
Oh,
yes.
that was the testimony of honesty.
Honesty that Mr. Boccone forged. Judge, if you look at the transcripts.
Is that true? To answer that question. Was there evidence in that from Mr. Honesty that Mr. Brown, Mr. Boccone forged Mr. Brown's signature?
I don't recall sitting through that trial and hearing such testimony, but I'll say that whatever the record indicates, but I don't recall Mr. Honesty saying that there was any forgery, because specifically,
Did he say that Mr. Boccone directed Brown to sign the prescription?
But then that's what was claimed. What happened when Mr. Brown testified? He said he was never directed by Mr. Boccone to sign anything. Dr. March said he was never directed to sign or give anybody prescription. Dr. Correa also testified that she was never told or given any orders by Boccone, because the government's essential argument is that Mr. Boccone distributed this narcotics by either talking the doctors into doing it or asking the doctors to do it on his behalf. But
This is very central, because it seems as though in the joint appendix, when you look at page 334, there's some indication there from Honesty in terms of what is supposed to have been done. And it seems there's one instance where, I think I recall, where you said that Brown had reduced his medication. Boccone got it, took the prescription and forged Brown's name to increase the medication. That's what he testified to. Whether or not it's true or not is his testimony.
it's like the problem with Honesty's testimony is like, apart from Mr.
Maybe a problem with it, but my question is, did he testify as such?
On page 334, indulge me 1 minute.
I mean, you would know. You said you had the trial. You would know whether or not he testified. Did he testify like that?
I just saw it on page 334. I just saw it on page 334 that he testified that he did sign Charles Brown's signature.
He? Who is he?
He, meaning Mr. Boccone,
Signed
Charles Brown's signature.
Called forgery?
But then the next question
Is it a question of fact? I mean, you may have a good point, but now we're kind of getting in the bailiwick of, you've got some evidence here to support what's going on.
Not if nurse practitioner Brown says that identifies that signature. He said it, Dr. Brown, and the nurse practitioner Brown said he was the one that signed that particular prescription.
Well, look here, I've just been pointed out to a portion of the transcript 331. This is of Honesty testifying. Did you ever witness Paul Boccone signing prescriptions? Yes, I have. Question, what name did you see him sign? Charles Brown.
Saying
Evidence?
It's like that's. I will say that evidence in terms of the testimony from a witness, but then the question then becomes, when Mr. Brown took the stand, he testified in this case. He was shown the prescriptions. He identified those prescriptions as prescriptions that he signed. So honestly saying that my client, Mr. Boccone, signed it is one thing, but then Mr. Brown, who testified on the oath, said he was the one that signed those prescriptions. Dr. Joel March also testified that he signed those prescriptions. Never saw my client, Mr. Boccone, sign any prescription. Honesty was the same individual that my client had to call the police on. Honesty was the same individual that my client had to testify against.
Okay.
Well, the problem you got is this is a jury trial, isn't it?
It was a jury trial, but then
I mean, you're making an interesting argument here. I don't think I've heard that before. You said you recognize this witness testified that, but your witness is under oath that he testified he didn't sign it, and therefore a jury couldn't possibly find that he did.
no,
Nowhere stated in the law. You won't get anywhere with that.
no, but it's like Judge Wayne, the argument that I'm making, or the point that I'm trying to make is, Mr. Honesty says one thing, but the documentary evidence on the record, which is the actual prescription in question, was identified by nurse practitioner Brown as his signature. So Honesty saying
He
that
also said some places he didn't have a signature. They were forged.
who said
Brown.
Brown on one occasion, Judge.
Look, one occasion's enough. I'm telling you, you've got to face the hard evidence, not the easy evidence.
Okay.
I mean, testimony that went your way doesn't help you. It's the testimony the government put in that inculpated your client that you have to address.
Specifically, I will address the.
Well, actually, you're through a red light now, and you'll have to reserve.
Okay, I guess I'll reserve, but I'll just say, Judge, that the report from Hamill Root should not have come in because it doesn't meet the American Medical Association standards, not one bit. But I will address the other remaining issues since I have to stay my time.
All right, Mr. Bennery.
Good morning, may it please the court. My name is Michael Benary. I'm an assistant United States attorney for the Eastern District of Virginia. This case was about Paul Boccone operating a drug distribution business with the essential help of nurse practitioner Charles Brown. If I might, Your Honors, I'd like to jump to addressing the sufficiency of the evidence with respect to the 3 substantive distribution counts against Charles Brown. The court asked several questions about what is the standard for a nurse practitioner versus the standard for an MD. And I would argue that it's exactly the same standard. And it's the same standard because in Virginia and other states where nurse practitioners are allowed to prescribe using an MD's license, they are standing in the exact shoes that the MD would stand in were it the MD at the medical practice prescribing.
Does it, and maybe you can help me on this. It seems like to me it creates another element of proof on the part of the government. You have to show that it was not for those purposes, I would think.
That is correct, and it's consistent with our jury charge in this case.
But the argument on the other side is that he's not bound by that. Then he becomes sort of like a layman. And then you don't have to prove it.
Right.
I'm trying to understand where does that go. Maybe I'm misreading that, but I see it on one hand as a benefit. You didn't prove it. But if you don't have to, because the argument is he's not a doctor, he's not a physician, so therefore he's a regular guy. So he's just like Mr. Boccone. You don't need to prove that.
I think that's...
Am I reading that wrong?
No, Judge Wynn, I think you're reading it correctly. However, because nurse practitioners in Virginia are allowed to issue prescriptions under a MD's license number, the argument
That's what kicks in the element.
That's what kicks in the element. And certainly you could take Defendant Brown's argument to say that we proved too much because we took on that extra element, but we did take on the extra element because it was abundantly clear and the jury found that these prescriptions were issued outside of the scope of medical practice, not for legit.
But his statement is almost like that element really is something, it's a higher level of proof from their perspective that you not only have to prove that it's medically necessary or whatever, but you have to prove that wasn't someone who ordered them to do it or who was a medical doctor, I guess, or if it wasn't within the scope of the things they were permitted to do.
That's correct. And an MD would have that same good faith defense.
What was the evidence that the Brown knew this was beyond the pale, these prescriptions that he, on the counts, Ms. Burnham says there's no evidence on those counts.
Yes, Judge Niemeyer, and it simply put, the 3 substantive counts were instances where the medical records reflect that the prescriptions were either issued or directed or the patients were seen by Paul Boccone, There was no medical visit whatsoever on the part of nurse practitioner Brown, yet Brown signs the prescriptions. Dr. Hamill-Ruth testified to give the jury a framework to view what's legitimate medical purpose. She testified that it was outside of the scope of legitimate medical purpose to issue these opiate pain medications without conducting any physical patient visit or seeing the patient at all. But even on top of that, of course, when you're dealing with...
Did you establish that Brown signed them?
Yes, that the prescriptions themselves are actually in the record, the originals.
Yeah, but how do I know it's not Mr. Boccone's forgery?
Well, Your Honor, even if they were forged by Mr. Boccone, and I would suggest that that wasn't what the record reflected, there was evidence that nurse practitioner Brown would sign stacks of prescriptions brought into him at the medical practice. But even if he did, there would still be sufficient evidence that Mr. Brown was aiding and abetting because he was assisting Paul Boccone, who needed someone, a teammate essentially, someone who's had a license to issue these prescriptions, whose name could be put on the prescriptions. Because if a prescription went to the pharmacy with the name Paul Boccone,
She argues that he didn't know.
And I would argue that that's just simply against the weight of the evidence. If you go back and look at a single witness, Eric Honesty, as the court pointed out, he testified directly. I think the question was something like, who did you have the agreement with? And his answer was, it was with Charles Brown and Paul Boccone, and that is on page 339 of the joint appendix. Additionally, there was other evidence that the two were working hand in hand together to distribute these drugs. William Dahl, who was the medical office director, testified that once Dr. Match came on board, and Dr. Match was the second supervising physician that was employed by Paul Boccone at Chantilly Specialist, when patients complained to Paul Boccone about Dr. Match cutting their medications, the patients would be rescheduled for a visit with nurse practitioner Brown, and the result was that they would be issued the same prescription that they were requesting not be cut. So there is significant evidence that Brown full and well knew that he was acting outside of the scope. There were other patients who were Charles Brown's patients who testified that they would come into the practice and as new patients through their entire time in the practice, where their prescriptions were jumping up and up and up, and not once did nurse practitioner Brown, who was their treating person at Chantilly Specialist, not once did he conduct a physical examination of them at the practice. And so I think that all of that goes to support the jury's finding that he was well aware of what was going on. He was in the conspiracy fully and had the agreement directly with these drug addicts to get them the pills that they needed. With respect to good faith, I would like to address that. And again, I mentioned that Dr. Match was the second supervising physician. The first supervising physician was Dr. Carol Currier. Both Carol Currier and Dr. Match testified that they did not approve of these prescriptions being issued, these incredibly large prescriptions to these people with obvious issues, addiction issues, diversion issues. And I believe their testimony was that had they known that this was going on, they would not have approved it. So there is no good faith defense here for Charles Brown because he did not have approval from his supervising physicians.
Let me move you just a little bit out of order, and then you can come back after
Yes,
this
Your
question I want to deal with on the sentencing.
Yes, Your Honor.
Does the calculation of the drug quantity in that PSR include all of the prescriptions written by Mr. Brown for these patients?
It includes all of the prescriptions written for select patients, not all of the prescriptions that Charles Brown issued for all patients of Chantilly. And the reason in the PSR adopted by the district judge was that there was a record to demonstrate by a preponderance of the evidence that the standard of care was breached for those patients. Those are patients who came in, and certainly in the past they could have had medical problems, but the record reflected that while they were at Chantilly Specialists, there was no legitimate basis upon which they could be issued any pills.
So these prescriptions are the ones that were written at the behest of Mr. Boccone and the ones that were not written for at the behest of Mr. Boccone?
Well, I'm not sure that the inclusion by the probation office rose and fell on whether they were specifically issued at the behest of Boccone or whether these were patients that Charles Brown was seeing during the life of the conspiracy and he issued the prescriptions. I think that their inclusion in the sentencing amount rose and fell on whether there was any legitimate medical basis to issue the prescriptions. There was a preponderance of the evidence found by the probation office, adopted by the district court, and certainly backed up by the record, that none of the pills issued to the specific patients selected for inclusion had any medical purpose. These were pills issued to addicts and drug dealers in the hundreds and thousands of unit amount, and so I would argue that they were correctly included. Notably, the sentencing guideline calculation that Defendant Brown argued for at sentencing was a level 32, which would have resulted in a low-end calculation of 121 months. Of course, as you know, Your Honors, he was sentenced to 60 months at the end of the day. And so, with respect to sentencing, if I could just close that loop, the position of the government is if there was, and we concede that the record from the district court is exceedingly brief for each of the two defendants. However, we would argue that this court can be confident that he, in fact, considered all of the sentencing arguments by both Boccone and Brown, even if it was not as explicitly stated in the record as we would have liked to see, because in the context of a well-briefed and well-argued sentencing hearing, the sentence that he imposed for both Boccone and Brown were significantly below what the government requested, significantly below what the district court found the properly guidelines range was, and actually closer, certainly in Brown's case, but also in Boccone's case, closer to what the defendants themselves requested. Brown requested a sentence of minimal incarceration, and Boccone requested a light sentence. And in the context of this drug distribution business, which resulted in numerous overdose deaths, very high guidelines range based on very high pill amounts, that for Paul Boccone, the sentence imposed 15 years is certainly significant, but much lighter than it certainly could have been. And for Charles Brown,
Does his guideline range go up to life?
his guideline range did go up to life. It was 360 to life. Again, and even if you, there is a point in the sentencing argument where Mr. Boccone's counsel talks about a level 32 again, because they're requesting essentially a fraction of a third of the number of pills that the probation department included, which would bring it down to a level 32. Again, you're still dealing with a guideline range of, at a low end, 121 months. Certainly with the leader enhancement that the district court found was appropriate for Paul Boccone, I would argue that this court can have confidence that the district judge did actually consider the sentencing arguments in coming up with the appropriate sentence.
Counsel, if you read the paragraph in the pre-sentence report, as I recall, that discusses the 4-point leadership enhancement, and you count the number of individuals named in that paragraph, you don't come to 5. Have you thought about that? Who are the 5 people?
Well, Your Honor, if you're talking about people that are actually co-conspirators, I would argue that you could easily get to 5. You certainly have Charles Brown. You have, I would submit, Eric Honesty.
No, the PSR, that paragraph explicitly excludes Mr. Honesty. The probation officer discounts Mr. Dow as well.
And even though those people are discounted, I would argue that there was clear evidence by a preponderance that they were members of the conspiracy. They were acting with these two men to get pills that they were then selling to others.
The probation officer came out on the opposite, and there's no discussion by the judge, as you recall. So there's no finding in the record as to what you just said, is there?
I would have to specifically go back and look. I know that the district judge was economical with his on-the-record discussion at the sentencing argument. However, I do believe that the record has a preponderance of the evidence that there were far more than 5 other individuals involved. Even just counting, not counting the patients, even just in counting other people at Chantilly Specialist over whom Paul Boccone had exercised influence. You have Nurse Practitioner Brown. You have, I would argue, both of the supervising physicians that Mr. Boccone brought in. You have
What you're pointing out is that the enhancement has the words "or otherwise extensive."
correct.
And
Your
now
Honor.
you're making the argument that you don't need to be fixated on 5.
That is true.
Okay.
As a fallback, I would argue that there certainly is evidence in the record that there were far more than 5, but and they don't all need to be viewed as co-conspirators to qualify as the 5. But even outside of that, when you're dealing with an enterprise involving this many patients traveling as far distances as they were, even up to 13 hours, it certainly would have been justified.
Would Dr. Fasano be one?
He would be. Dr. Frazier would be another one. Melissa Lavoie, who is the Medicare biller, I think there's clear evidence that she was acting at the direction of Boccone based on his own testimony that he brought her in as the Medicare biller. Certainly we know that bills were submitted to Medicare that were false. She would have gotten that false information because Paul Boccone was conducting the patient visits from Paul Boccone. She acted at his bidding, even if it wasn't completely knowingly as a co-conspirator. So I would argue under either standard, the record supports the imposition of the enhancement.
What is the evidence to support count 9 against Boccone? It's against both Boccone and Brown, but I'm just interested in what the evidence against Boccone. That's April 5th.
Certainly, Your Honor. Count, if I may just flip to it in my notes, please. Count 9 dealt with Michael Rogers. Interesting. Counsel today points out that Michael Rogers didn't testify during a trial. Of course, he was an overdose victim, was long dead by the time our trial occurred because he had been overprescribed by Boccone and Brown. The evidence was that prescription was directed by Boccone and signed by Brown. The prescriptions in evidence, the medical notes of that April 5th, 2010 visit indicate that the prescription was directed by Boccone. Of course, if the jury finds that to be true, he's guilty of distribution of drugs because he has no medical license and can't prescribe at all. With respect to Brown,
And what was the evidence that he directed that one?
it comes from a review, primarily a review of his medical file. And you can see in the medical file, as is discussed at some length in trial, they had an electronic medical record system. And so you actually could see the user in the system who was inputting changes to the prescription, inputting the notes concerning the prescription, and the notes associated with that visit indicate that it was Paul Boccone. And if the jury found that to be the case, that's sufficient. That is sufficient evidence to find him guilty of distribution of controlled substances for that count. Of course, Michael Rogers ends up coming back 3 days later on April 8th, getting a new prescription, which was far earlier than was scheduled, and is found dead on his mother's couch of a drug overdose that same day. He was traveling from Tennessee, which does share a border with Virginia, but certainly not with Chantilly, Virginia.
You said there was more than one. How many people died from overdose?
Well, there were counts in the indictment dealing with 2 overdose deaths, Jonathan Heiser and Michael Rogers. The jury ultimately found the defendants, I believe, guilty of distributing the drugs, actually not with respect to Jonathan Heiser, but they did not find them responsible for the death resulting, which would have been a sentencing enhancement presented to the jury. In Dr. Hamill Ruth's report, there is a discussion of a number of additional patients who also died of drug overdoses, but those were not specifically charged as substantive counts. They were incorporated into the conspiracy count. And so, unless the court has additional questions.
All right, thank you.
Thank you.
All right, let's see, who's next? I guess, Ms. Burnham, you're next.
I'll address the sentencing arguments first because we didn't get to that last time. The government is incorrect that there's no evidence that there was a legitimate medical purpose for any of the prescriptions for those 4 individuals. For example, they all suffered from real pain conditions. You can see that in the briefs and in the record. So in addition, the fact that he ended up getting a below guideline sentence that's completely irrelevant, because the question is not whether the sentence ended up being within the guidelines range or not. The question is, was the process infected by this error? And it's quite conceivable that the judge would have given him an even lower sentence had he started from a correctly calculated lower guidelines range. And the failure to explain error is not harmless either, because the very nature of that error is that it's not susceptible to appellate review, because you don't know what the judge was thinking, what he considered or what he did not consider. On the sufficiency of the evidence, the government says that the evidence was that Mr. Brown didn't have approval, but that's not the way the practice agreement worked. He had approval as long as the physician wasn't telling him to stop prescribing or advising him that there was a problem. So every time he wrote a prescription, he tacitly had approval for those. And to the extent
could he write a prescription for 1,000 units of OxyContin, say, and give those to the patient who said, "I hurt"?
If he, in good faith, believed that that was acceptable medical practice, then
So he
yes.
does have an independent duty to apply accepted medical practice when he's prescribing.
Correct, with respect to what he knows to be accepted practice, which is in part defined by what he's being supervised.
And there's evidence that a lot of the patients he didn't actually physically examine at all, and he signed stacks of prescriptions.
There was
Is that
also,
accepted medical practice in prescribing drugs?
actually, I believe that it was Dr. Match who testified that it is within the bounds of medical practice to not examine a patient every time you see them. And the government's expert also opined in her report that or perhaps it was her testimony, I'm sorry, but that it depends on the circumstance. You don't just order tests to order tests. You don't just perform
You
routine.
think Brown was issuing these prescriptions without knowledge that he was feeding drug addiction on this record?
I think whether he knew the patients were addicts or not is not the same question as whether he believed that the prescriptions
My
he was
question was, do you think Brown knew when he was prescribing these drugs that he was feeding drug addiction?
No, I think the record does show that he was perhaps a negligent nurse practitioner. He could have followed up more. He could have, though it's hard to see how, he was in daily contact with the supervising physician. I mean, I guess you could say he could have sought outside help from outside the practice or something, but
I mean, a customer comes in one day, gets a prescription, comes in a few days later, gets another prescription, and then that very same day overdoses. You know, bury your head in the sand as to what's going on. How long was he at that clinic? 2 years?
2.5 years.
2.5 years.
And when he started there, he had no background in pain management.
I know, but, okay.
I think it does, there's things about it that are not great. He might be negligent, but the question is not, was he a bad nurse practitioner? Was he a negligent nurse practitioner? The question is whether he had effectively ceased to be a medical professional at all and was just pushing drugs, and the evidence just does not show that.
Okay. All right,
Thank
we
you.
have one more rebuttal of Mr. Iwanage.
Thank you, Judge Nehemiah. With respect to Mr. Boccone, I would like to shift gears and go into the sentencing argument. The issues raised by Judge Flanagan are very relevant. 5 or more people, what we're doing by counting, it could have been this person, it could have been that person, is basically we're speculating. As Judge Nehemiah asked the panel, the argument before us, specifically, what is the issue before us? Isn't it immutability? Judge, the issue is the record indicates that we don't have 5 or more people for the role enhancement. We cannot sit here and speculate what it should have been. the specific 5 people should have been identified on the record for the purposes of the enhancement, the fallback position doesn't even work, because specifically the enhancement...
What if we had a business run by a mafioso that had 30 employees that he was directing? You have to identify the 30 employees?
The evidence has to show, the sentencing judge has to identify the employees who were being directed. Just because an individual is an employee doesn't mean that they're being directed.
This enterprise, this is a racketeering enterprise that has 30 employees. Now, my question is, in the judge in sentencing, does he have to identify the 30 employees or name at least 5 of them to get the enhancement?
I will
Or
say that
could the evidence show that there were 30 and he could just leave it at that and issue the enhancement?
Judge, I will say that the record has to direct us to something that the judge is relying on. We cannot speculate as to what number of people that were directed or managed within the
So
group.
you think that if the evidence was there were 30 people in a business and the judge doesn't say anything further about it, it's pretty well established, there was 30 people that the defendant was directing, that we're speculating?
I will say that it will be speculation because it has to be shown by preponderance of the evidence. And preponderance of the evidence, that's why you have a sentencing hearing, that those issues are supposed to be fleshed out. Like Mr. Benari eloquently stated, the issues were well briefed. If the judge wanted to make that finding, it should have been made on the record. He adopted the pre-sentence investigation report as is, and then we're stuck with it. In addition to that, there's no specificity as to which medications or which number that are not for legitimate medical purpose. That plays a number with the quantity of drugs in this case. Dr. Hamil Roots and the government did not tell us how much of this medication was not for legitimate medical purpose. And lastly, the other point that I have is the issue with respect to the improper closing argument by the government as to the voluntariness of Mr. Boccone's appearance before the police officer to Special Agent Walker to take his fingerprint. I'll submit that when you were told that you have something for you to show up and you on your own go over and then you're given something to sign after you get to the location, that you went there voluntarily, being advised that there's a grand jury subpoena pending is one thing, showing up on your own to have it done and have it executed is something.
But you know, there's a difference between a prosecutor vouching for the credibility or not of a witness, and there's a different proposition of the government arguing that the evidence showed that somebody lied. And this argument, the government was pointing specifically to that testimony and making the argument that that was a lie. Now, that can be counter-argued, but I'm not sure that on this record that was a vouching a problem.
The only problem, not that it's vouching, but then when the prosecutor then says that Mr. Boccone was on the stand, he testified on the oath, the prosecutor had I asked him specifically about whether he went there voluntarily, and he said yes. And then I'm supposed to rely on the evidence adduced for purposes of my closing argument. The prosecutor had a crack at Mr. Boccone. They did not ask him that specific question. In closing argument, they bring up this issue of him having to show up pursuant to a grand jury subpoena. Now, I'm relying on the fact, because I was not previous counsel, that there was some grand jury subpoena that was actually issued to him, served on him for the purpose of appearance. Come to find out after the fact and after the correction.
So your argument is that he was relying on evidence that wasn't in the record? Or I thought your argument was a vouching argument, that he was giving his opinion that the person lied.
In addition to the fact that the government led us to believe that Mr. Boccone showed up at Sully Station pursuant to a grand jury subpoena, the argument that I made before the jury was that he voluntarily showed up at the Sully Station and was subsequently served. So based on those reasons, I ask that this court not affirm the conviction in this case.
Let me, you were court appointed.
Yes, Judge.
I'd like to recognize your service to the court. Thank you.
Thank you, Judge.
And,
Newman. We'll go on to the next case and then maybe.
All right, we'll come down and greet counsel and then proceed on to the next case.